Can the foreign spouse and/or foreign children of a Filipino or former Filipino citizen be allowed to live or reside permanently in the Philippines? In other words, can they be given a permanent resident visa or immigrant visa in the Philippines? We'll talk about that after this. Hello everyone, kumusta po kayo? I hope that you are all doing good. This time, we will accommodate the query from Miss Juvie Trinidad. Miss Juvie says, "Hello attorney, can you make a video po about what legal benefits will marrying a Filipina bring to a foreigner? Will they be allowed to live permanently in the Philippines now that they are married to a Filipina, etc.? Thanks and more power." The way I understand it, Miss Juvie wants to know if marrying a Filipino citizen would give a foreigner an advantage than simply settling in a common law or live-in relationship. But I would like to address the question from the legal point of view, focusing mainly on the question whether or not a foreigner who marries a Philippine citizen can live permanently in the Philippines. Indeed, by marrying a Filipino citizen, a foreigner could qualify to apply for a permanent resident visa subject to other qualifications. Such marriage opens a wide possibility for a foreigner to reside permanently in the Philippines and to enjoy what our rich and beautiful country has to offer. Besides, living with your spouse is one of the most important decisions to make after your wedding. There are actually two pathways by which a foreigner's spouse may apply for a permanent resident status in the Philippines. One is the 13A visa and the other is the 13G visa. There is actually a third option which is known as the SRRV or the Special Resident Retirees Visa, but I will not be discussing it here because it is not dependent on marriage with a Filipino citizen or a former Filipino citizen. I will discuss that instead in a separate video. First, let us take up the 13G visa, which is also known as the Balikbayan Visa. In this visa, the foreign spouse as well as the foreign children of a former natural-born Filipino citizen can be included in the application for Non-Quota Immigrant Visa in accordance with Section 13G of the Philippine Immigration Act as amended. When we say non-quota, it means that there is no limit as to the number of applicants that can be entertained in this kind of a visa. For the 13G visa to apply, the applicant foreign citizen must be the spouse or the child of a former natural-born Filipino citizen who was naturalized as a citizen of a foreign country and who intends to return to the Philippines for permanent residence. The 13A spousal or marriage visa, on the other hand, is issued to foreign nationals who have contracted a valid marriage recognized by Philippine laws with a Filipino citizen. The application can be made in the Philippines through the participating office of the Bureau of Immigration or abroad through the Philippine Embassy or Consulate. If the application made while in the Philippines is approved, the applicant will initially be given a 1-year probationary status, after which the same will be re-evaluated to determine if the applicant is qualified for conversion to permanent resident status. For 13A visa, it requires that the applicant foreign citizen must be the spouse or the unmarried minor child under 21 years old of a Philippine citizen. In the case of the foreign spouse, there must be a valid marriage certificate recognized by Philippine laws, and it also requires sufficient financial means to support themselves and their family. The 13A visa is a multiple entry and non-quota immigrant visa type, which means that there is no annual limit on the number of applicants, and this visa allows permanent residency. So, what is the difference between a 13A visa and a 13G visa? The difference is that in 13A visa, the spouse is a Philippine citizen, whereas in 13G visa, the spouse is a former natural-born Filipino citizen. Please take note that the grant of permanent resident visa in the Philippines works on the basis of reciprocity. It is available only to a foreigner whose country of origin also grants permanent residence and immigration privileges to Filipinos. So, permanent residency is available only to nationals of any of the 84 countries with reciprocity agreements, giving the same immigration privileges to Philippine citizens, among which are the United States, Canada, Australia, United Kingdom, and Japan. Please take note also of the following criteria that may be looked into when you apply for a permanent resident visa in the Philippines. First, that there is no record of any derogatory information against the spouse in any local or foreign law enforcement agency, that the spouse is not afflicted with any dangerous, contagious, or loathsome disease, that the spouse has the sufficient financial capacity to support a family and will not become a public burden, and if the spouse is already in the Philippines, the spouse was allowed entry into the Philippines and was authorized by immigration authorities to stay. For the visa eligibility requirements and processes, I will put the links in the description box of this video. I hope that you have learned something from this video. Please don't forget to subscribe to this channel if you haven't done it yet, and hit that notification bell icon so that you will get notified of our future videos. Always remember, ignorance of the law excuses no one from compliance therewith. I will see you in my next video. Ingat po kayo.